Welcome to the Boardroom Soldiers, the podcast that talks to owner-operated businesses about identifying and eliminating business crime so that the honest can take their hard-earned money home. From your hosts, Pierre Gildenhuys, GM of D&K, myself, Kyle Condon, owner of D&K Investigations, we welcome our esteemed guest, Mr. Daniel Krynauw, who is the CEO of the Invictus Group, a position, Daniel, you've held since inception, 2002.
Yeah.
Okay.
Thanks for the welcome.
With over 25 years of experience in the labor law field, you're seen as a leading expert in the field itself. I know you've been on or spoken in various publications. You've been published on various matters. Your thoughts and opinions on the labor law environment is obviously well known and respected. So it's a pleasure for us to have you here. As investigators, it's great to give our listeners, our clients, an opportunity to perhaps hear from your side what it is that labor law representatives, attorneys, etc. do. I know that the Invictus Group is one of the biggest companies in your field. You've got a proven track record. You have offices in Cape Town, Durban, and Johannesburg. You have a huge social media trend and can be found obviously on the various social media platforms like LinkedIn, Facebook, and Twitter. So I would recommend that after the show, when someone's heard the show, they should go and have a look at the Invictus. You can give us later your handles and stuff where we can, obviously people can go and visit that. But as for today's show, let me just, again, warm welcome to our listeners, new and old. Boardroom Soldiers, the history behind Boardroom Soldiers is obviously for us as business investigators. We find that, running a business in today's day and age can at some stages feel like you're in a war. Your boardroom can become a battlefield. And one thing I've learned over the past 30 years is that, you need a toolbox of sources, allies, typically soldiers in your corner. The Boardroom Soldiers acronym and name came from the fact that it's all great to run business, but when you've got to go to war, you're going to need some people in suits and ties who are prepared to get down and dirty for you, which is where we come into play. And obviously, through the years, have met good folks like yourselves and respected companies that not only out there in the typical trenches and rolling up your sleeves and representing clients both ours and yours, but that is what the history behind the show is. And today will be a perfect opportunity just to touch on a few of these things. We may have to do a follow-up show. There's so much we could really talk on when it comes to the background and how important labor law is. Is it correct for me to say labor law? Is that the correct way to say it?
Look, I mean, the formal term is probably industrial relations.
Okay.
I mean, if you go to varsity, you study industrial relations.
Okay.
Not just labor law.
Labor law. Okay.
But, your analogy with war is actually very interesting because in the labor law field, it's probably like any other field. It's not about war. It's more about the battles and daily skirmishes.
Yes.
Okay,
that's
and it's not just one battle and you're done. It's a daily battle.
It's ongoing.
The more staff you have, the more battles you're going to have. That's just the way it goes.
I think that's an important point. Now that you mentioned that, I have this sort of cynical outlook that I suppose has come with years of sort of dealing with the corrupt side of business and the criminal element in the workplace. But my view is, if you've got more than one member of staff, you have a problem. And it sounds terrible, but that's how it is. And obviously it's not literal, but the more staff you have, the more propensity there is for issues. And that's where obviously you guys are now playing a huge role.
Well, every single employee you have got their own issues. They've got their own problems in life, their own levels of performance. And, nobody is uniform. If we could be uniform, life would be very boring indeed.
Indeed it would.
Yeah.
Tell me, and for the sake of those listening, in a nutshell, Invictus, what is the name Invictus? Where was that derived? And what is it that you do? Your elevator pitch in the sense of what Invictus does and delivers your solutions. What are they? What do you do?
Okay, so let me give you a little bit of background because it's actually quite interesting. Well, to me it is. So when I studied law at university, we still had to study Latin.
Okay.
I'm not kidding.
Yeah.
Okay. These days, for anybody listening who's a current attorney or we only had to do LLB, yeah, I've got words for you. Okay. We had to do Latin. Okay. Now, if you look at the history of South African law, our law is based on a combination of Dutch, English, and Roman law. Okay, which is Latin. So we have a lot of Latin expressions in law. Okay, and the word Invictus was first recognized when the poem that Nelson Mandela read the 1995 World Cup team was called Invictus.
And the movie.
Okay, and the movie was called after the poem.
Okay.
Exactly. Now, for anybody listening who wants to read the poem, I'm giving you a heads up. It is the most depressing piece of poetry you will ever read in your life. Okay. The word Invictus means overcome in a direct translation. Okay, and that is where the word comes from, that it's got Latin connotations, but also a South African connotation in terms of the word. And that's why we chose that.
Interesting.
So if you go look at our logo, okay, I'm not punting the company, I'm just telling you
No.
on there. Because this is related.
You can.
The logo is Sedant Armatore,
Okay.
which means let arms give way to the toga. So instead of fighting wars, have it decided in a senate or in a legal setting where in Roman courts everybody wore togas in the senate. Sure. And that's the translation, and that's the connection.
The pen is mightier than the sword.
Well,
and in your
I think we've seen that in business.
Yeah. Well, Pierre, just in what Daniel's explained there, I think that word overcome.
It's overcome.
Overcome. I think for you the challenge as an investigator and burying yourself deep into all the trials and tribulations that our clients and businesses have out there. I think sometimes you too sit back and you just say, fuck it, I'm overcome. And overcome by probably a feeling of despair at times.
No, it is.
And so it's an interesting choice of words, but I know that you've sat with me and said, I feel overwhelmed even at times. And then you find a solution and you've overcome that challenge. It's almost like a double meaning.
But there's always double meaning in absolutely everything.
Yeah.
That's the fun part about this.
It's quite a deep meaning behind just the name of the company and the sort of image.
Look, I think that, reflects on myself and my partner taking it very seriously.
Yes.
Okay, it's not our hobby, it's our life.
Yeah.
And it's our goal in life. Okay, when we started this off, and maybe we can cover this one day on entrepreneurship. Yeah. Okay, we weren't chasing money when we started this. We wanted to build something.
You went off and studied law originally.
And then I did an honours in labour law.
Okay.
So was that originally what you wanted to go into when you studied law?
No. Can I tell you how I ended up there?
Yeah.
Okay. During my time, I had two choices. Go to university or go to the army.
Yes.
I was going to Bloom Special Division. Okay. What is the longest thing at varsity I could study? Law. Great, I'll be doing that.
And what varsity did you go to?
RAU, that's now UJ.
Yeah. The new UJ.
Yeah, the new UJ, the old RAU.
The old Rand Afrikaans University.
That's the one.
So you went off with all good intentions to study law, branched off into labour law, and was Invictus a creation that came shortly thereafter, or was it?
We worked for other people before, okay, and in a roundabout way ended up together, and that's how we started.
And now, if I had to say to you, to a young person, a young school leaver, matriculant, somebody in that line, looking to go into a career, would you recommend it as a career? And B, what is the requirement? You still have to certainly go study law, I would imagine.
Yeah. But the reality of this situation is, it's not for everybody. Okay, it's not for everybody, because similar to you guys, nobody phones an investigations company because they are happy with their staff or happy with their business, right? So every call you get is negative.
Good
The
point.
same thing works with us. Nobody phones us to tell us how well their employees are behaving and how well the business is doing, etc. We don't get those calls.
Well, look, if that was the case, none of us would be in business.
Well, exactly. Okay, so it's a constant negative influence. So I always say to people, etc., if you want to go study something, okay, go study it. What's the worst that can happen? Okay, I've got friends of mine that studied with me that end up in IT.
Sure, never
Okay,
completed what
you're
they
not
wanted,
necessarily going to end up where you studied. But if you find your interest in life, because law is also so wide. Now, the interesting part about labor law is we've only had the new Labor Relations Act since 95. Now, for any legislation, that is nothing. Which also has the effect of every single new case that comes out, it changes the application of the Act. Every single change that comes through is a change in the Act. Every CCMA rule that changes is an interpretation, it's a different way of doing it, etc. It's a constant changing environment. If you go into maybe estate law or tax law, the chances that that will change majorly, okay, except for what is announced in the budget speech every year, is pretty constant. I mean, I think the Tax Act still uses 1956 as Tax Act. Okay, it got amended a couple of times, but effectively, you know, we've had 70 odd years of the same Tax Act. Okay, for labor law for 25 years, because remember, the moment the Constitution came in, the labor law changed.
So it morphs,
Exactly.
and it's a living thing.
So it's a new area,
Okay.
etc. And it's not for everybody. I mean, some people enjoy criminal. I personally would never, ever step anywhere near it. Okay, some people enjoy private law, some people state law. There's so many different divisions in terms of that you find your passion.
What about labor law specifically attracted you to branch off specifically into that?
I think for me personally, I like the idea of riding into the rescue. I've probably got a white knight complex or something. I'm sure some psychologists will have an
Here I
absolute
come,
field day with that.
charging the light brigade.
But I like that, okay? And also, I like the underdog. And most businesses these days are the underdog because employees are heavily protected. The law is not equal in this area. Okay, it is heavily favored to protecting employees. And, you know, in terms of our history, etc., as a country, it probably should be. Okay, but that's a very debatable subject. Does it stifle
incredibly
employment?
Yeah, it's
Does
an
it
incredibly
stifle?
important point.
Does it stifle economic growth?
You touch on something there that I think it's a strong point of mine and peers, certainly with as investigators, because we feel that in the current climate, the employee is protected to such an extent that the employer sits often on the back foot in the corner, just getting slammed left, right, and centre. And I understand, the history and all these things, but it is like that, and it feels that way, and I think it is that way. Now that you mention it, and I can attest to this, is as a company that supplies undercover agents, for example. You know, I read these undercover reports every week as they come in from our informers that have been placed. And the amount that employees can get away with, and they know that they can get away with, so they push the boundaries, is disheartening. It's disheartening. I mean, I've seen business owners and executives almost in tears, with their hands up in the air saying, you know, what do we do? What can I do? And yes, that's where, as investigators, our role is to come in and assist with getting the evidence, and then having persons like yourselves and your staff come in and run with that to get the underdog into the favourable position at the end of the day.
Well, you got to remember, any case is only as good as the evidence.
Absolutely, yeah.
You know?
So yeah, it's a valid point you make, and I think it also goes down to. Does that stifle employment? Absolutely, I think it does.
Yeah, but probably interesting also to touch on the whole evidence thing, okay? Because there's a difference. In criminal law, you've got to prove it beyond a shadow of a doubt.
Correct.
Okay? In labor law, you only have to prove it on a balance of probabilities.
Yeah.
That's all we need to prove. Okay, and that's sometimes where people get a little bit stuck in the woods if they don't have an expert or they're being advised by a criminal attorney. No, no dissing.
So now,
Cumulative.
in your define what is it for you that is the
51
balance of
If
probabilities?
51% of the evidence says you did it,
So does
are
that
guilty.
So does that mean now? I know the answer to this, but I want you to explain this to our listeners.
absolutely, 100%.
And we face this problem a lot. Where does 51% mean I polygraphed my employee? He failed it, but I don't have anything else.
Okay, this is interesting because it ties on to the whole evidence thing.
Because
So-
certainly that would tip the scale in favor of the employer.
So polygraphs, okay, can't be treated as main evidence.
Why not?
Okay, I'll tell you now. Okay, so I'll give you the perfect example. There's 5 guys working in your company. You test them all. The 3 fail, you fire all 3 of them. It doesn't work like that. Okay, it can only be used as supporting evidence. Okay, but now I'll take that same scenario. There are 5 guys who've got access to a storeroom. So only 5 guys in the whole company who've got access to the storeroom. Something goes missing out of that storeroom that can prove it was never invoiced, it just disappeared. The only logical explanation is one of them took it.
Absolutely.
You test all 5, 1 failed, that's the one who took it. On a balanced probability, here, there, everybody else passed.
Now,
Because remember, in the polygraph, you ask specifics.
Cool,
It's
sure.
not general.
No.
And now, the reason why it can't be treated as, the reason why you
Oh,
can't
yeah.
treat it as main evidence, okay, is that it's not 100% reliable.
Correct.
There's an element of doubt.
Yes.
So therefore, it can only be treated as supporting evidence. It can't be a witch hunt to go find out if somebody ever took anything ever. Because if you ask the question wrong, have you ever taken anything from the company? I think I took a pencil a year ago. You'll fail.
Yeah.
absolutely.
It's got to be about that specific instance and that specific thing that went missing.
That bottle of water. Did you steal that bottle of water out of that storeroom?
That's it.
Yeah.
Now, Daniel, just on the issue of the burden of proof with evidence in terms of labor law and for the companies, because I suppose you get this a lot, because I know we do, and it's frustrating. Even to the extent, I've had this at commissioners at the CCMA, not quite understanding, scary as that may sound, but true, where a client will misinterpret or be led to misinterpret what is balance of probabilities, as you've got a nice definition you gave there, and a good example, and will believe that because I suspect you enough, it's you, and therefore fire the person.
Well,
Or
we get
hearsay.
this a lot. Yeah, we get this a
So
lot.
don't you find it frustrating?
Not really, because you got to realize you're dealing with somebody who hasn't gone to varsity for 6 years, who hasn't worked with this on a daily basis. And now I'm going to go back to one of your previous points. As an employer, as a business owner, you've got to be a tax expert, you've got to be a specialist in your field, you've got to be a labor law expert, et cetera, et cetera, et cetera. You've got to be an HR expert, name a field.
Whatever, yeah.
Like an IT expert, etc. You can't be an expert in all fields. Okay, you surround yourself with providers that are reputable, and then you are judged on your team providing. You can't be an expert in all fields. Okay, so you've got to realize that the person you're dealing with is a layman. This person wasn't trained like this. In their understanding of what law is, okay, it's what they've seen on TV. Okay, now the American judicial system works vastly different, okay, to the South African one. Okay, it's not Lincoln Lawyer that you're going to have here. Okay, the evidence works different, the system works different, and it is not in half an hour the case is wrapped.
No.
Sometimes it takes years. Like a case that goes into CCMA, Labour Court, Labour Appeal Court can last anything from 5 to 8 years. And it's actually very interesting. I mean, if you go back to a well-known case that was broadcast everywhere, the Oscar Pistorius trial, that showed people what court is actually like. Okay, that it is not.
point.
It is not the Lincoln Lawyer where people get up and perform and do a song and dance, and the jury convicts or acquits them.
Danny Crane.
Exactly, Boston Legal. There we go, classic.
Okay. So, going then, if we're taking the evidence matter into, well, we've covered that, and I'm glad we did, because it is a frustration that we do encounter. I know you do a lot, where there's a preconceived idea of what an outcome is going to be, even where you've sat and said, I don't believe there's sufficient evidence yet, or I don't believe that what we have here, based on a balance of probabilities, is still significant enough. Okay. The other side to that is, of course, I know you've had situations where, I mean, it's not even probabilities anymore. It's beyond reasonable doubt because there's video footage, et cetera, et cetera. And you've still had then, I'll say it, you've had Labour lawyers who've argued against us in that particular case, who, for whatever reason, believe differently. Yes, they've studied the matter, and we've always respected that. But, you know, just like they've studied, we've spent 30 odd years doing investigations and presenting this evidence. So there is often not often, wrong word, but there is from time to time a clash between what we believe. But what I am happy to say is that in the private sector, the successes are far more than what you encounter, and I and you, but what you out there on a daily basis encounter when you're dealing with the police, who have no concept of burden of proof and basically throw everything out because it's just as easy to close a docket and say, I don't know what they
don't even understand
it's fraud,
it.
I don't understand it. And I wish there was Labour lawyers based at every police station that can decide on a Labour law matter if there's a criminal case or not, because that's where it gets sort of this grey area that occurs.
So I mean, on that basis, okay, as I said earlier, there's different divisions in law. Okay, now we as a company, for instance, only do labour. We don't touch criminal. Okay, it's the client's choice if they want to press a criminal charge or whatever the case may be, because lawyers don't normally typically drive criminal cases. Okay, the state has got a duty that the moment you press a charge for them to investigate and then pursue the matter. That's what you pay taxes for. Okay, our job as labour lawyers, etc., is to get rid of the problem and make sure it stays gone. Okay, and then prepared for any litigation that may follow. Okay, that's where we stop. Anything that happens past there from the criminal side, that's up to the state and the client if they want to press charges. Remember, not every single person that gets caught stealing, there's a criminal charge for.
Absolutely not.
Sometimes it's just not worth it.
No, we'd have a bigger backlog than we do anyway.
Exactly.
Daniel, okay, staying with that but moving on slightly, because I think this leads nicely into a point here that I wanted to bring up. We're moving into then the disciplinary process. In this example, hypothetically, D&K has gone in. We've done the investigative work. We've obtained as much evidence.
Good evidence.
Good evidence. I'm going to, in my example here, I'm going to use that everything is worked well and evidence has been forthcoming, etc. What is it that then generally jeopardizes that case in terms of procedures? Because that, to me, is another issue, is the correct and the incorrect disciplinary procedures. Many HR practitioners, I find, are not sufficiently educated, and maybe educated is the wrong word, maybe it's just experienced, but they fall flat on procedures, and I've seen cases lost on procedures. What's your take on that?
Okay, so I think let's go to the definition of what's a fair dismissal first. Okay, so a fair dismissal is based on two legs. Okay, fair procedure, so what procedure was followed to initiate the dismissal. Okay, now procedure is either right or it's wrong.
Can't be in the
Okay,
middle.
there's no grey area. Okay, there's a set in terms of Schedule 8 from the LRA set. This is what a hearing is. This is what constitutes the hearing.
And what
These are
what needs
procedures
be
to
done
follow it.
prior to the hearing.
Exactly. And case law during the years have actually made it very clear on this is the steps that need to be followed.
Absolutely.
Okay? It's either yes or no. Now, if the answer is no, you lose. Boom, over.
Simple.
Okay? It's simple because you gotta have both those legs legit. If you fail the first leg, you're dead. You lose. Okay, so let's assume the procedure was done right. Okay. Second leg is then the substantive reasons for the dismissal. Now, there is a couple of grey areas here, and it depends on interpretation, etc., and case law changes this, etc. But was the reason why the person was dismissed fair. Now, the word fair is the bane of my existence. Okay? The word fair comes from the Constitution. Okay?
Can I just stop you to ask you a question?
Yes.
In criminal law, is that the word fair is turned to the reasonable man? Is it the same thing?
Very similar.
Similar, okay.
Similar. Okay? But because the word fair is in the Constitution, in terms of everybody should have the right to fair procedures. I mean, if you're really interested, you can actually go read that whole section. Okay? Because of the word fair, we have the whole LRA, we have the whole CCMA, we have the whole Labour Court, we have the whole Labour Appeal Court, all to determine what is fair.
And that's why they always take the company for unfair dismissal.
That's it.
Right.
Correct.
Mm-hmm.
Okay. Now, that is the reason why. Now, has that reason been communicated to the employee? Did he know that if he broke that rule, he would be terminated? They also look at, was dismissal the appropriate sanction? Was there no other way short of dismissal? These are all things that the CCMA then debates, and that's normally when you have a case at the CCMA, what you argue.
Now, you say there, was the, let's say, the company rule communicated to the employee in a form of a contract or verbally said, but does it always have to be, can't you rely on, sort of,
So
every reasonable person knows that I'm not allowed to steal.
So can I tell you our biggest frustration in this game is common sense.
Yes.
Okay, because it sounds like common sense.
Yes.
Really, it sounds like common sense. I caught the guy, I fired him, stole.
Yep.
Common sense, right?
Not always.
But the law doesn't work like that. The law says you've got to do this, and you've got to do that, and you've got to follow that procedure before you can terminate, because people have got rights.
This is just out of a...
So sometimes common
side.
sense...
Yeah,
Okay.
common sense is dangerous.
Is very, very dangerous.
It is
because it
dangerous.
makes sense. And
it's
then
not
common
that common.
sense to me, common sense to you, and common sense
Two
to
different
you
things.
is 3 different
and
things
I,
already.
and I can tell you an industry that is beset with that particular is the security industry,
Yes.
as in security guards.
Yeah.
And I mean, I know
Sleeping on duty.
how many over the years we've caught that common sense would tell you that you don't put your shotgun on your toe or sit on it like a chair outside a shopping centre, and when it goes off, say, well, you shouldn't have done that. Well, it's common sense to say, to get told, well, nobody told me that.
Yes.
So I get what you're saying. Common sense is
I've
a
got
dangerous
so many
thing.
security guard stories.
Yeah, but common sense, there's that old saying that a little bit of knowledge is a dangerous thing.
100%.
Common sense reminds me of that. Is it that common?
Yeah, common sense is not common.
Yeah, but okay, so that's
that is-
where you're going. Yeah,
That is the biggest problem. Because business owners go, but that's just
it's
common
normal,
sense, right?
Yeah, it's normal.
Okay, but there's still a legal procedure to follow. It's that simple. Okay, because everybody's presumed innocent until proven guilty.
Correct.
Either beyond a reasonable doubt or, in this case, on a balance of probability. Everybody has the right to a fair procedure. And also, going on the whole right thing, I challenge anybody listening to this. The employee that's probably your worst employee in your business knows his rights better than you do.
Absolutely. I think that is seen often. Often.
Never assume that people don't know their rights. People know their rights.
They know them, and they, I find this very often you think because no disrespect to the position, but you think, well, the chap's a forklift driver, and his employer decides he's going to dismiss or he's going to do something. I'll tell you what, he gets taken to the cleaners by that forklift driver because they know their rights. They know the labour law better than very often most business owners.
And
know the labour law.
in a lot of times backed by a huge union.
Well, what you got to remember is, what is the cost in referring a case to the CCMA?
Zip.
0. You know why? Because it's a constitutional right. You can't be charged for exercising your constitutional right. Now, if you've been fired, as horrible as this sounds, you've got nothing better to do.
Yeah.
Might as well go to the CCMA.
fact.
It's not going to cost you
Pain in the
anything.
arse for us, but yeah.
In all the years that I've been doing this, I've probably in my whole life gotten costs 3 times against an employee. 3 times.
Explain when you say cost.
The costs of the proceedings.
In other words, ruled in your favour or your client's favour that
That's
they
it.
have to pay.
The costs that got
Interesting.
wasted in terms of not just the client's costs, but also the CCMA costs.
How would one get that? Is that like is that a civil thing you have to do separately? Or
No, it's part of the judgment that the commissioner will.
Commissioner, all my years I've never heard of it.
A commissioner will very, very randomly, very seldomly in this case, award costs against an employee. It's different in labour court.
Interesting.
In labour court, if you lose with cost.
Yes,
Doesn't matter what
with
side
cost,
you're.
yeah.
But in
Yeah.
the CCMA, to be awarded, or in even a bargaining council, to be awarded cost is a rare thing indeed. So the risk for the employee is zero.
And
Even if they got caught dead to rights, etc., on video camera. And this is where people go, but how can he go to the CCMA?
Yeah, of course.
He got caught on video camera. There he is taking the stuff.
He has a right to be heard.
Well, it's just go there because you've got nothing else to do. Let's go.
Well, what is it going to cost him?
Nothing.
Zero.
Absolutely.
Okay, why wouldn't he go? Because sometimes in life, I mean, this is how the system is rigged. It might be cheaper to settle with the employee at conciliation than actually go fight the arbitration, which will be in 3-4 months' time. Getting everybody that needs to testify there, etc., paying the cost of having it litigated. It becomes a business decision.
Okay.
So now the employee got money for doing what? For exercising his right. Why wouldn't he go?
And,
So
and,
then-
and am I correct if I say a lot of the times they go there just for a settlement?
Absolutely, 100%.
Well, that's what,
because
it
they
almost
get told
becomes-
to.
And it almost becomes, we walk in there, we almost pulled aside immediately.
And say,
and
listen,
said,
we'll
listen,
give
don't
you
you guys or your client just want to settle?
Yeah.
And you said, but we've got a case here that's, we can't lose. And they'll say, well, just pay him something and it's...
Yes.
yeah.
That's how the system is rigged.
Yeah.
Now, also got to remember, all these employees watch the same shows that employers watch on American TV.
True.
Okay? Oh my God, I'm going to get a R1 million settlement.
Yeah.
Yeah. This is where it comes down to. Okay? People think it's a get rich quick scheme by going to the CCMA. Because if you go read any newspaper, you never read in the newspaper the employer won. It was a fair dismissal. You very rarely read that. What do you read about? Oh, the CCMA awarded compensation to this person or reinstated that person. It's always, because that's a much easier news angle.
Of course.
Okay?
50 striking workers reinstated.
Then the employee dismissed 50 striking workers and won the case. Boring. Who wants to read about that?
Okay, so just quickly on the procedures, what are they in the sense of first thing that you need to do as a company? Your HR department has to do what? Notify the...
So how it works is there's got to be a notification in writing, okay, of a disciplinary hearing to the employee.
Okay.
Then the employee has to be given enough time to prepare. Now, what that time is relative. What is fair time? So most normal times is 48 hours to prepare. Okay? Then there's a hearing where there's a chairperson, a complainant, the employee, maybe a representative from inside the company, depending on the legalities of it. Okay? Then there's an outcome and a ruling from the chairperson, etc. That I'm skipping over a lot of stuff now,
Yeah, sure.
but I mean, if we have to go into what a hearing entails, we'll be here for the next hour.
Yeah.
And then there's a recommendation.
Yeah, the chairperson doesn't actually fire the
No,
person.
they give a recommendation to the company of what their verdict is.
Right.
Okay. The company then chooses to exercise that verdict.
Point now for listeners. The employees who are sitting who have been charged in that hearing, what is their right in terms of a representative? Are they allowed a lawyer?
No.
Or is it only a company representative? How does that work?
They're only allowed an internal representative.
Okay.
Unless one of the accused is a shop steward from a union, then most of the times, which is not automatic, is allowed. But I mean, most companies or attorneys will allow the fact that a union will come represent their shop steward, okay, for fear of victimizing a shop steward because he is a shop
Because he's a
steward.
shop steward.
But most employees
But no lawyer allowed. No legal
Emplo-
mind.
They will be allowed an attorney or a lawyer, etc., if the other side is being represented by an attorney or lawyer.
Okay.
Because then the law likes to
Then
balance
it's fair.
things. It likes to balance things out. Now, the same works for the CCMA. Okay? Your lawyer can't go represent you in a conciliation. They're not allowed. Okay? When they go to arbitration, an attorney is not automatically allowed to represent. They have to do a legal application to appear and show reasons why they should be appearing. Because the whole process is set a lot more informally than court. And, you know, that's a whole system in itself.
And again, I'll use the word accused, but they rock up at the CCMA. Who is allowed to represent them at that initial process?
Only themselves or a union?
Not a lawyer.
Not a lawyer.
Okay. Just want to put that out there.
Yeah,
It's
just that
not my
everybody
rules,
understands.
But this is
That's
so
the
everyone
rules.
understands. This
Yeah.
is how it works.
So they should be there, one man alone or woman or one person alone, 1v1. Correct?
Look, the reality is, as there are people like me who represent companies, there'll be people representing individuals.
Yes.
And, you know, and they'll appear as members of a union. It's, people make a
I've seen
living.
that with LegalWise, and I'll use that name because I've seen people do this.
Yeah. But also, there's LegalWise, there's Scorpion
Yeah.
Legal Services, there's plenty of these insurance companies, etc., that you can actually take out. That'll actually pay for representation up to a point,
So
depending on the policy.
The employee is allowed one of those representatives.
Well, they'll only be allowed a union representative or a fellow employee representative. Same as in the hearing.
Okay.
Will be allowed at the CCMA.
The hearing takes place once it's adjourned, considering in this situation that the evidence is compelling, it's there. What is the next step?
The chairman will then do a recommendation or an outcome. Okay?
Okay.
He will then recommend what appropriate action is. Did he find the employee guilty of the offence? How did he find the motivation behind it, etc.? Now, the quality of this judgment, if you can call it that, okay, is dependent on who you use. Okay? I've seen ones that are a page, and I've seen ones that are 16 pages. Okay? It all depends.
Okay.
Okay? There's no fixed procedure how that should look, or laws that say how it should look. There just has to be that recommendation. But obviously, if the judgment or the recommendation is of low quality, okay, it's going to get torn apart at the next process if it goes to the CCMA. You've got to prove. As a chairperson, you have got the obligation to provide your reasonings behind it, etc. The case law that this case is dependent on, because every single employee, doesn't matter what they've done, deserves the right to a fair procedure. And you've got to show that. It's not a slapdash thing. And this is now where your problem comes in when HR people involve themselves into this process. They are not legal people. This is a legal process. Okay? And sometimes that is when things go a little awry, if you want to call that.
Now, what is the risk for business owners, HR, when they have let's call them a headache employee? There's something that happened, and perhaps the company is in two minds themselves about whether they have enough to fire but they sort of, coerce the chairperson coming to chair the meeting saying, listen, I want to get rid of him, make sure it happens.
Effectively, the chairperson should never be coerced in any sort of shape or way, because then the chairperson isn't completely neutral and not completely fair, which means you'll probably lose that if it comes out afterwards.
Thank you.
One could argue, though, and this
And
is something
also the reality of it is,
Yeah.
just continuing on that process, for companies like ours, it's bad business losing cases. Okay?
Absolutely.
Therefore,
Same as us.
you're not going to go and do a recommendation where the chances that you'll lose are huge. Okay, it's bad business.
Yeah.
It'll probably be the same for you guys.
It is.
Basing all your evidence on hearsay.
Well, yes.
You would want to be able to say to a client, I've never lost a CCMA case.
Well, you'll also be able to say our chances of winning this
Haven't, though, actually.
is 75,
We haven't. I'll
80%.
put that out there.
That's where you want to be. Okay? You don't want to say to a client, the chance of us winning this case, 51%.
I'm just going to throw something out there, though. This flies in the face of all three
Sure.
of us. Okay,
Shoot.
is that if I had to be completely unbiased in any way, when a company hires, starting with investigators, and then certainly going across to a labor law representative to come in and chair the hearing, there is almost, one could say, one could be accused, put it this way, I've got to choose these words carefully, but one could almost be accused of there's an element of biasness that then exists, because I'm paying, not me, but the company is paying for a labor lawyer to come chair this particular hearing, and hopefully they're going to find in my rule in my favor at the end of the day. I understand that they shouldn't, if they, if they're ethical and professional, if there isn't sufficient evidence. But it can be almost misconstrued as because you're paying the bill, you're going to get what
results.
you want. Yeah.
Yes.
Now, and I'm not saying that is the case. What I'm saying is we get accused. People accuse us and labor lawyers of this. We, as investigators, will very often get told, and this will happen at CCMA, that you fabricate evidence because you can't lose the case. Because if you do, you're not going to get paid. In fact, I've had this many times in criminal courts. And that is, it couldn't be further from the truth, because the reality of that is we are not paid on results. Quite simple, nor as you guys aren't. We do not earn a cent on a result.
100%.
We are not, as in, for example, debt collectors who collect cash and they take a percentage. If they don't get, they get or traces. As investigators, we are going to be paid, whether that case turns out in favor of an employer or in favor of the state is irrelevant. We're getting paid for the hours worked.
The doctor analogy is always a winner.
As the doctor, he's getting paid whether you die or not.
Yes.
Yeah, the surgeon, you kick the bucket on that operating table. You're paying that anaesthetist. You're paying those people.
Yeah.
And we're the same. So I'm just putting it out there, though, because I do understand how many times people do say to us, or they put it across, because you paid, because the company paid for a labor lawyer, it was inevitable they were going to win this case, initially anyway.
Yeah.
And I say, no, bullshit, because the labor lawyer is going to get their bill to you. You're going to pay them regardless. They're not out about the result. They're out to stick to the facts, as we do. Stick to the facts, present them. If what we present is not winnable, it's not winnable. I mean, that's just the way life works. That's how it is.
But this is what we discussed earlier. Doing a bad case is bad for business.
It is bad for business.
Okay?
But
Therefore,
we still have to do presentation of what there is.
But let's take this now the other way around. Okay? A company gets external investigator, they get an external chairperson to chair their internal matters. They can't put any pressure on that investigator or external chairman. They can't say, listen, we're going to withhold your bonus if you don't dismiss this person. Which means the internal person that might chair that hearing has got a lot more pressure to keep his boss happy than what you as an independent has, about getting assigned a certain task and actually performing it.
Why I push for independent all the time.
Exactly. You make a ruling on the facts.
And HR hate us for it, but that's the way it is.
Look, I mean, HR will have reservations about it, but I think the moment an HR person understands that this is a specialized area of law, okay, because that's why HR people get referred as HR generalists. It gets covered under generalists, okay, a part of it, but you are not a specialist. And the difference between that is, I always say to people, if you need to go for an operation, you can go to the GP. He knows where everything is in the body. He'll probably get it out of you some way, okay? The scar he'll leave, as opposed to if a surgeon that specializes in that period of the body does it. It's two separate things.
This is going back to the house we blew up.
Yes, just like that.
Yeah.
Exactly. An analogy on our other show that we did. But
it's a speciality. That's really what it comes down to.
And that's the same as investigations.
Absolutely, 100%.
Just because a man wore a blue uniform, drove around in a van for 30 years, does not make him an investigator.
100%.
And the same goes in your industry. So with HR, etc. Right. Moving on from that, Daniel, I want to bring up an issue here which I think you guys must deal a lot with, because if we do, it means you surely are as well. But it is investigating in and around the whole restraint of trade issue.
Okay, so very simple.
Please explain this.
Very simple. There's such a misconception about this. It's unconstitutional. You can't keep somebody from working. You name it. I've heard every single argument.
Yes.
Now, the Constitutional Court has ruled on this. Okay, restraint of trades, okay, are enforceable. Okay, but
So you heard it here. They're enforceable.
But there's always a but. Okay, the restraint has got to be fair. Okay, now there's
Determined fair.
There's that fucking fair, the F's. Okay.
Okay, there's always that.
Fucked
Okay,
by the filthy finger of fairness.
so
That's what I like.
I'll give you the perfect example. The period has got to be defined. It can't be indefinite. Okay? The area has got to be defined. It's not indefinite.
Okay.
So are you saying they should say that if I sell water bottles...
A good restraint of trade will cover about at least 4 pages and will spell out exactly what you can't do. Now, I think let's look at the purpose of a good restraint of trade. There's a good and there's bad ones. Okay? Same as divorce agreements and those type of things. Okay?
Story for another day.
A good restraint of trade says you can't go compete against us directly. You can't go poach our clients. The whole purpose of a restraint of trade is to eliminate unfair competition. You know what we charge because you worked for us for how many years? You know who our clients are and what we charge. Exactly.
Yeah.
It's like corporate espionage. It's exactly the same thing. Okay, that's the aim of a restraint of trade. It's not saying you can't go work in the same industry. It says go work in the same industry. Just don't poach our clients, don't poach our staff, don't use our knowledge that you gain through us against us. Because then the competition in the marketplace is not even. It's not a fair fight.
Yeah.
And that's really all that it comes down to. It's really not that complicated.
Yeah.
Okay. Now people think, yeah, but if I've got a restraint of trade, somebody should pay me for the whole period. No, it doesn't work like that. Okay, there's nothing in law that says that. This is not a golden parachute that the CEO of a listed company gets. Okay, it doesn't work like that. It all depends on what is in that restraint of trade. It could have a period in, it could have a monetary value in it, etc. Okay, and let me tell you the scary part. Personally, I've been through this fight in my life. Okay, is that it's not about how enforceable that restraint of trade is. Okay? It's the cost of defending it.
Defending it, not as in the person who's supposedly done wrong defending, or the employer.
The employer will never defend it.
Okay, he's enforcing.
The employer will always enforce
it. So the person accused.
Nowhere in the world has an employee ever tried to enforce a restraint of trade against themselves.
Okay, so forgive me for terminology, but just making sure.
But this is the
accused.
Yeah.
Okay,
so the employee and the employer, because that's the two parties involved.
Quick one though. Does the wayward or ex-employee who's joined Company B, and this is what we see, they joined Company B because Company B poached them. So they bring their IP and they bring all of their stuff across, and they hit the road and they break all the restraints.
Yeah.
Who pays for that though? The company that brought them in or them themselves?
So how it would normally work is the company that lost the employee or has the restraint of trade will normally write a letter to the company that poached and inform them that the employee they've taken into employment has got a restraint of trade. Okay, now, that employer then has 2 choices. Okay, do something about it and rectify, or do nothing about it, carry on. The moment they then carry on, they are party to breaching that restraint of trade.
What can they do?
So there's a couple of different ways that you can do this. Okay, there's a very aggressive way, and then there's a smart way. Okay, the aggressive way is bringing an urgent interdict against the employee. Okay, to enforce the restraint of trade. This is why, because it's urgent, it's expensive. You're probably looking at a good 250 grand to bring an urgent application in court. Okay. That is like in a day or 2. That matters on the roll. Okay? It is huge. Okay? Normally the court would rule and put an interim order in place and then review it to determine if they're going to make that order permanent or not. Okay, that's how that process works. It's not that complicated. Everybody exchanges documents. It's like a normal court case. It's just on an urgent basis because the matter's got to be decided urgently. Then there's a very smart way of doing it. So let's use, for example, the restraint was for 12 months. Okay? As Company A, you send the letter saying, please note, this guy's under restraint of trade, blah, blah, blah. They don't respond or they don't do anything about it. You wait 12 months and then bring a suit of damages against the company that broke this restraint of trade and the employee.
Calculated from what you think your losses.
That's it. So there's different ways of doing it. It depends on the strategy, etc. But either way, it's not a pleasant thing to go through, let me tell you.
No. But now from your side or our side, but your side, if you give us an example, you've just done a nice investigation recently on exactly this. 2 staff members, am I right?
2, yeah.
Left same company, joined opposition,
Yeah.
and then moved aggressively into securing what was clients of the previous employer across to the new company.
Yeah.
And just talk the listeners through that.
So I'll define it as a sales position.
Okay.
I think that's fair.
Okay.
Funny how it normally is.
Yeah.
Yeah.
And that's where the headache comes. I mean, sales are lucrative and a cutthroat industry, but 2 employees working for company A resigned, moved over, or actually got headhunted,
got headhunted and resigned.
Yeah.
With almost
immediate effect, yes. Then went after the clients that were clients of company A. So they said, listen, remember me, I've joined a new company, let's start doing business. So our client contacted us, said, listen, we need help to prove what was going on, even though they know what was going on. So we sort of did a dirty on them, called them in for a quote on what they were selling, captured everything.
We terminology-wise, what we call a false flag approach, where I suppose a bit of a honey trap at the end of the day, but ask them to come in and present.
You see, I would have a problem with that in terms of evidence.
Okay.
Because that is what we call entrapment.
All right. So just on this, and this is it's a good debate.
And this is where, again, we go back to our previous conversation about the quality of evidence.
Yes.
It can't be entrapment. It can't be hearsay. There's all these different type of things.
So what we did in this particular situation, and because I'm cognizant of the entrapment issue that goes around this, and although a lot of that is based on, I suppose, ethics, but the 2 individuals here were asked to present a sales pitch on the business that they're currently at. They advertise out there, it's on the internet. So they were phoned up, come in and please present to us what it is your company will do and has done. That was where it sort of ended. They offered way too much information at their pitch in terms of
Where
previous company where we worked
100%.
would rip you off and do
100%.
X, Y, and Z.
But that's the difference between entrapment and
That's
this
why I
all
sort
the
of-
evidence.
sort of starting to
in terms
badmouth
of their
them.
conduct.
So the way we do it is obviously, and again, this comes down to, I suppose, experience. But they were given an open platform, but they hung themselves in that platform. The matter did go to CCMA actually, and was won there by the client, our client. They won that, but the CCMA found that the dismissals were well. Firstly, there was no dismissals, but it went.
They went for constructive dismissal.
Constructive.
Yes.
That was found no problem.
Well, let me tell you why they went for constructive dismissal, just to interrupt. They went for constructive dismissal because if they were unfairly dismissed, you could claim that the restraints aren't applicable because the company broke the law first.
Yeah. Okay.
That's why they did
Well,
it.
then it went a step further where our client proceeded with civil action against offending Company B and won that case on the basis that the evidence that Pierre and his team had provided was there was no issue in that evidence. In the end, cut a long story short, I mean, it was a very successful case. But in the realm of restraint of trades, there is this continual sort of companies not knowing what they can enforce and they cannot enforce.
Well, this is why the quality of enforcing it goes down right back to basics about the quality of the person who drafted it in the first place.
That initial restraint of trade
How good was
contract.
the restraint of trade that was drafted and signed?
Well, theirs is always very good in this particular case.
Because if you've ever been through a case like this, what happens is that restraint of trade agreement gets torn apart by both sides. Okay?
Trying to find every little
find
escape.
that loophole or
Yeah.
something that was grey or something that is left to interpretation to render the entire thing invalid. Now, there's in simple contract law, you can't agree to something that's illegal. If you can find anything or any point in that contract
illegal,
that's illegal,
correct, yeah.
okay, it renders the whole contract illegal, including the restraint.
Just another thing on the restraint of trade investigations, though, that you've got a lot of success from is surveillance.
Yeah.
A good, decent surveillance, securing evidence that is admissible, showing constant contact with clients, etc., that they are prohibited by the restraint from doing, which you've done a lot of, which is again another way of doing it. Okay, other one, Daniel, is this in this current day and age, it seems to be rife more than ever. Sexual harassment.
Oh shit.
Sexual harassment, as a business that represents the company on hearings, etc., are you finding there's a spike in it? Do you think
Very few and far between.
you find less?
Very few and far between.
Okay.
Very few and far between. Okay.
You should come have a look.
Maybe we need to refer more to you because
Yeah.
we get so many of them.
We don't find that a lot. Okay.
Why do you think is that?
I think because in the current woke age, without being horrible to young people, okay, people are a lot more sensitive about what it actually entails, and a lot more conscious of what the definitions for that is. Okay, there's also the Employment Equity Act. There's stuff like that.
One would think more would do that, though, with all the sort of the GBV rules and stuff.
Well, this is where I'm going next. We're seeing a lot more of that. GBV cases are a lot.
Okay, so you see a spike in those.
Oh, yes. And it's not just between employees.
No, sure.
Employees can't come to work because they were assaulted by
Partner.
the partner. Yeah. Or the partner's been locked up for GBV.
Yeah.
And can't come to work.
Do you guys represent company on those?
Well, we don't represent them in the GBV cases.
No, but if they proceeded with
effect on employment.
Employment, yeah. I'm saying if it rolls over into eventually.
It's very difficult in terms of somebody who gets arrested, etc., and because you have to link it to their work, for instance.
Of why, if they're not there and they're not doing a job.
So sometimes this happens a lot in gender-based violence cases where I'll just a typical example of the man hits the woman. She goes and press charges, he gets arrested. 2 days later, she goes and she drops the charges. But now he's been off for work for 2 days. But you can't discipline him for being away from work because he got kept against his will by the government. He didn't have a choice. He couldn't come to work. It was impossible for him to perform his duty.
So what's the company to do?
Well, there's nothing you can do, okay? Because the government, if they arrest somebody and they keep them against their will in a jail cell for 2 days, they can't come to work. It's impossible for them to come to work. That's the best excuse ever, except maybe being in a coma or whatever.
Yeah. Let me just interject there. When you say someone is arrested, this is something that we deal with very often, is the impatient client that sees and going on the presumption that all of the evidence are clean-cut, secure, no problem with it. It's almost to a point where it's beyond reasonable doubt. This employee stole something. They call the police.
Yes.
That's the first thing they do.
Jump
all
the
the
gun.
time.
Jump the gun.
Call the police, say, listen, we catch somebody right here. He's trying to get out of the gate. Come get him.
Let me tell you this horror story. Okay?
Expand.
Let me tell you a typical example of what happens. Okay? The employer catches the guy stealing.
Yeah.
Catches him on him trying to take it out. Okay? He takes the stuff back. He calls the cops. They arrest him. They put him in a jail cell. Okay.
Indefinitely.
He doesn't have money for bail. So he sits there.
Yeah.
2-3 days later, whatever the case may be, he appears in front of the magistrate. Okay? The magistrate goes, where's the file? Lost the file. He finds him not guilty.
Come back to work. Re-employ.
That afternoon, that employee walks back into the shop. I'm back. I've been vindicated. I've been found not guilty. You can't go discipline him now.
Correct.
For something that he got found not guilty.
By the state.
By a court of law. Okay, so how this works. Remember we had the incident earlier about the rules and how we're going to follow the procedures, etc. You always do a hearing first. You terminate the employment. then
Thank you.
you press criminal charges. Now, the nice part about that is you've normally got about 33 years to press criminal charges. You're not running out of time anytime soon.
No. Thank you, and I'm glad you said that
Happens
because
all the time.
I've had headaches and fights. On
So
this
no
matter.
matter the severity,
Do your hearing.
make sure the employee is off your books first.
You got to do things in a certain way.
He's the
First
state's
you
problem after
terminate,
you.
then you make it the state's problem, as you said.
Yeah,
That's the right way of doing it.
It is an old school mistake made coming back from old school security personnel, where they would catch you, and you haven't even effectively removed the item yet off the property, for example, but you're caught, you're arrested, and you're fired within hours.
Yeah.
But also, the old school way of doing it is correct, okay? Because this was the law before 95.
Yeah, that's what I'm saying. Then it worked.
Yeah, remember, we still, before
Now.
95, we still had the free strike rule.
Yeah, not now.
That's one of the biggest banes of my existence again. When I go to a client, they go, yeah, but we gave him free warnings. That means he's fired, right? This is not baseball. It's not free strikes and you're out.
Yeah.
Okay, there's a procedure to be followed. Free strikes and you're out was before 95.
But now that old school technique doesn't work, and this is exactly, come back to your point, is dismissal because he was caught and he's now in the hands of the police. He could be there for a week, a day, a month, a year, and then the re-employment because you fucked up, because you had that without actually even having a hearing, because he was just taken away.
Well, not only the fact that you have to reinstate him, but continuously pay him
Well,
throughout
the
the
back
process.
pay, etc. So I've seen that it is a horror story. I like the word horror because it is a horror story, and it's one that doesn't have to happen. It's just stupidity from the employer's perspective.
Yes.
HR and security. But yeah, okay.
Well, this is where common sense again comes into play.
Yeah, there we go.
Which
Don't
is
use,
not that common.
don't use common sense.
Topic close to our hearts, and one where I think you guys, can be quite messy. Strikes.
Yeah.
Companies, staff goes on strike, do their thing, and in the process the intimidation starts.
Tyrebraai.
And the tires, and the vandalism, etc. Strike ends 2 months later, everyone's back to work, company says, but what do I do? In the case of D&K, we've got video footage because we've sent strike teams out, etc. What is the company's rights? What can they do?
Company can dismiss. Okay.
Follow
because
procedure.
they're not dismissing for striking. They're dismissing for the
Thank you.
conduct during the strike. Now, a strike is either one of two things, right? A strike is either a protected strike or an unprotected strike. Protected means they followed the procedures to strike. Now,
In which case, if they don't do anything wrong during the strike, you can't touch them.
well, we're going there, okay? What you've got to understand is we're one of the few countries in the world that has got the right to strike in our constitution. Remember I said earlier, go read that part in the constitution. Well, every single employee in South Africa has got the right to strike. That's in our constitution. But it's not a right like, for instance, people think free speech is you can say whatever you want. Now, the right to strike doesn't mean you can strike whenever you want. Okay, you've got to follow
There's
a
a way.
procedure.
There's a correct way.
Exactly. Okay, now that way is not simple. Okay, because it's not in the government's interest to make it simple for you to strike. Because if people strike, they're not getting paid for that strike, which means the government doesn't get their tax. Okay, they want to make it difficult for people to strike. There's a whole procedure to follow. Now we assume they followed it. Okay, they went on strike for something that they can actually strike about. They go and they burn the tires, they do all of that. When they come back, or even during that strike, you could dismiss them for the conduct during the strike. It's all about the conduct. Okay, you can, so let's just backtrack for a second. You can dismiss for three things legally under the Act as it is at the moment. Conduct, okay, capacity, and redundancy, which is retrenchment.
What is capacity?
Operation. Capacity is, for instance, you are too sick to work.
Okay.
That's the procedure that you'd follow with somebody who, for instance, has lost a leg.
Okay. Okay.
As a security guard.
Yeah.
He doesn't
Can't
have the
fulfill his
he
function.
can't fulfill that
Okay.
function. Okay. He, it's a medical capacity.
Okay.
It could be any type of medical capacity.
Okay. Now I got it. Just wanted to clear that.
And then you have operational requirements, which is retrenchment. So the word retrenchment, funny enough, okay, is not mentioned anywhere in the Act. Okay?
That's interesting.
It's dismissal due to operational requirements. But we know it, and everybody knows it as
It's a
retrenchment.
nicer word. So just going back to the strikes. So,
So
conduct.
going back to that, it'll be under conduct.
So strikers.
Not because they striked,
No, not at all.
because of what they did during the strike.
Wildcat strike, down tools.
Now we go to the second part, unprotected strikes. That is a strike that did not follow the procedures. A wildcat strike is a perfect example, okay, and the most common occurrence. So what happens is the employees get excited about something that they perceive as is an injustice. They take law in their own hands. Okay, now here's the procedure that follows for that. First, they have to be sent an ultimatum to return to work. Okay, please note that you are on an unprotected strike, please come back to work. Then there's got to be a time set for them to come back to work, say 2 hours. Then there's got to be a second ultimatum issued, okay, which is by close of business. Then a third ultimatum to return to work the next day. Now the reason for that is there's case law that says they have to go back, see their families, realize that if they get dismissed, they can't feed them. They need to calm
The
down.
common
and
sense
cool
isn't
off.
applying, so you've got to do that.
This is
yeah.
not common sense.
Yeah.
This is the way that procedure works. This is law. It's not common
That
sense.
is-
It's law.
That is crazy, but okay.
If they the next day continue to strike, then it's a concerted effort on their part to strike illegally, well, unprotected. Okay, therefore dismissal is applicable. If they come back the next morning, oh, we're so sorry. It was a bit of an emotional reaction, etc. Probably the chances would be they would not be dismissed.
Yes.
Okay, unless there was obviously misconduct during the strike where it was damaged or whatever the case may be, etc.
So you have to issue those 3 letters quite quickly.
No. You issue them as they are because you've got to give enough time for them to react on it.
Right.
Because they've got to meet and they've got to discuss. And all you want to prove is that there was a concerted effort to break the law in terms of striking. You've got to show that. Okay? Because, again, we go back to the fairness aspect of it. That is the fairness aspect of it. Was it just them emotional? And the court realizes that people are emotional beings and they might react emotionally. Okay, but if they were given a chance to actually consider what they're doing and they kept on doing it, dismissal is applicable.
Going back now to the crowd that's jumping up and down at the gate. Legal strike. Got the paperwork.
Yeah.
Companies supposed to have followed their side of demarcated areas, etc. All of that stuff. However,
Picketing rules. Is what
all
they
the
call it.
picketing rules. But they barricade and prevent the company from trading. They put
Urgent
the rocks,
interdict.
etc. Interdict. Is that conduct dismissible once it's all over now? The fact that you
It's difficult to say without seeing it because they could all just be blocking the entrance.
I'm talking about placing boulders and tires and stuff so no trucks come in and out.
Yeah, could be.
A typical thing that they
be.
do. But
Could
okay.
be.
Oh,
Because also
interesting.
remember, you're going to bring an urgent interdict now. The court is going to rule that they are interdicted and the court is going to move them.
Yes.
So normally what the court would use as an indication is they would look at the streets surrounding the business.
Okay.
And they'd move them over those streets. That's normally how they work in terms of demarcation. Okay? Now breaking that is a criminal offence. It's a court order.
Okay.
Okay, it's contempt of court. But the conduct that they committed during it could be dismissible. I mean, it's never 100% it is dismissible, unless it is something that they are torching a van or committing
But
a
the
criminal
moral
act.
of the story is, as the company, provide the evidence.
Well, the company has got the obligation to prove
Yes.
their accusation.
So make sure your cameras are working. Make sure if you've got a strike protection team or whoever
There's
out
a
there,
drone.
there's your drones. There is evidence, and this is I can't stress this strongly enough because this is exactly that. It doesn't help come out, well, they intimidated Daniel, and now Daniel won't testify because he's scared. I understand that, but there's not much that we can do then.
And the reality of it is that happens a lot.
Yeah.
Where the actual person who is going to testify doesn't want to testify. Okay? And there's nothing like court where you can go testify incommunicado or whatever. the
I
case
want to
may
ask
be.
you,
Doesn't work
hearings.
like that.
Can you do hearings in camera or not?
Yeah, you can.
In other words,
Virtual hearings.
virtual hearings.
Yes, you can.
Okay, maybe I didn't ask correctly.
Witnesses can be virtual as well.
Can their identities be kept?
No,
Not.
because you've got the right to face your accuser.
Aha. That's what I wanted to know. Okay. So
Yeah,
that
you
makes
can't be confidential and not tell you who is actually testifying. No, because you can't prepare for something like that, not knowing who it is.
So it's
is
not
actually
fair.
doing it.
technically.
Exactly. You have
that
to
word
got
again.
the right to face your accuser.
So even an undercover operative, if he was going or she was going to be used in a hearing, they're going to have to sit there physically.
Unless the accused admitted that actually happened.
Yes,
and
yeah,
it's
but
fact.
it-
Then there's no need to testify.
No,
on it,
fine.
because
But
it's
I'm saying
common
the accused sits there and goes,
It's
no,
common
nothing,
cause.
did nothing. And you've got the undercover operative who's now got to back this up.
I'll give you this, just following on this chain of thought. You also can't cross-examine an affidavit. So
Okay.
an affidavit can't be treated as evidence unless somebody testifies to that the validity of it.
Okay.
Because you can't cross-examine an affidavit. It's a piece of paper. You've got the right to cross-examine or examine the evidence put against you
Yes.
or face your accuser. Yeah. Once again, we go back to that point.
Okay. Fake sick notes.
Dismissal.
Do you get a lot of those cases?
Plenty.
What type of evidence and how do you prove it?
I'll tell you what we're getting a lot more now, okay, because it'll tie into your question, is we're getting fake work permits.
Yes.
Yeah. Exactly the same thing. Any fake documentation that is presented, okay, is dishonesty. It's dismissible.
Now, does that apply when a company fails to do a due diligence or pre-employment screening, hires the employee, and only 2 years after the employment realizes that this guy has a fake passport?
So the way it reads is that you've got a duty to act the moment you become aware of it. Okay. I mean,
Yes.
if your procedures, if it slipped through the procedures or it looked genuine or now suddenly immigrate, and this happens now a lot. Okay, this is the current issue that we've got in this country right now is work permits. So now what is happening, immigration is raiding businesses. You thought all these guys had work permits. Here we go, I've got them all on file. Turns out the moment immigration arrives and they go check these things, half of them are fake.
Onus upon the company?
Remember what I said earlier? You're supposed to be a tax attorney, you're supposed to be a labor attorney, a commercial attorney. Now you're supposed to be an immigration specialist as well.
As well, yeah.
Okay, it's impossible for everybody to be an expert in everything. And some of the fakes are really, really good. They're really good as people make a lot of money through this. Okay, the moment you now become aware of it, you've got to do something about it. If you were aware of it 2 years ago, but you just kept the guy employed, then you've got an issue.
Yeah.
Which happens.
Yeah.
I mean,
And how would you, what type of evidence would you expect for a sick note? I mean, how does the employer go about receiving this?
The sick note, again, we go back to how was the sick note leave or the leave policy drafted? How well was it drafted? Okay? Because normally what happens is the sick leave policy will say, this is sick leave, this is what we need on the sick note. We need a practice number, we need a cause of why you were off, etc., etc., etc. Okay? Because bringing in a sick note or a clinic note, it's not good enough. Funny enough, it's not good enough. You need to be booked off, medically incapacitated of working. You weren't able to work. Now, what happens is employees go, well, I've got sick leave. I'll make an appointment and go see the clinic to get my medicine, and the company must pay for it as sick leave. That's not sick leave. That's shopping. There's retail shopping, going to this game, but I'm giving you time off.
I'm going to repeat this, though, because I'm glad you said this, and this is so important. The companies out there need to make sure that you leave nothing to interpretation when it comes to what is expected on a sick leave note, practice number, address, etc. And that is an issue that you will find when investigating sick notes, is that the company doesn't actually have what they want. So Joe walks in and he supplies this piece of paper, but if he really is clever, or he has a representative in the union who's clever, he says, well, show me where that's not acceptable according to the company. The company doesn't even have a policy about what is expected on a sick note.
Well, just in terms of that as well, the company has got a right to investigate that sick note.
Yes.
Okay,
Which we do.
You'd be surprised how few companies actually do.
No, we do it because we tell them we want to investigate these sick notes for you. But and then we'll go out and send the team out there and find that what is the doctor's practice is in fact a Chesenyama.
There we go.
And at the back is a guy sits there and he's got a pile this big with a stamp, and you pay your $50 and
or a printer.
Or a printer, and then you get your ID card as well while you're there.
The printer is amazing. It's a one-stop shop.
Yeah, quite literally.
But it is a problem that companies do not stipulate their own requirements. which is, and this is exactly why it's so important to have specialists like Daniel here. It's to tell people it's not our rules.
Yeah.
It's not you or me saying, well, this is where you fell short. These are requirements that the labor lawyers and representatives are going to tell you need to have if you want to fight this.
So, Daniel, at the end of the day, your absolute advice is make sure that initial contract is done as thoroughly as possible.
Again, another analogy for you. When you're building a house, you make sure that the foundations are right before you build the house. Now, it's exactly the same thing. Anything you're going to do in terms of employment practices has got to be built on the right documentation, the right policies, and the right procedures. It's as simple as that. Okay?
Leaving nothing to the imagination.
No. Well, I mean, there are certain
Nothing
things,
to
like,
common
for
sense.
instance, I don't have to put it into a policy that you can't steal from me.
Yeah.
Because it's criminal.
Because it's common sense.
Okay? No, because it's criminal, not
It's
common
common
sense.
sense.
Okay? I should actually
needs
put
to
it
be
into the
fair.
policy, but common sense shouldn't apply in these cases.
Yeah.
But the reality of it, it's got to be built on a solid foundation. Okay? Not something like, okay, well, I'll add a toilet on at a later stage. Okay? Not right now. Okay? I'll add it when I actually need one.
Or coming to the realization that you should put in a contract that
Because you're
the
always going to try and
company's-
play catch up.
the company
Okay.
is allowed to polygraph you whenever they want, something like that.
Well, I'll give you the perfect example of this. Okay, in 2020, parental leave came out for males. Okay, they said, well, if the female is getting maternity leave, then the male should also get it.
Yeah.
And they got 15 days. Okay. Today, you'll still have people who their sick leave or their maternity leave policies and paternal policies have not been updated.
Yeah.
Okay, and
right.
they think that 15 days is paid. It works exactly the same as maternity leave, which you have to go claim from UIF. It's not paid by the company unless your policy dictates that it is. Okay, I mean, it's simple things
it's
like
small
that.
things. I've burnt, and I mean, there's that old adage. They always say that a plumber's house has the worst plumbing, or
And a shoemaker, kids don't have shoes.
Yeah, exactly. And as an investigator,
And a preacher's son.
Yeah,
Yes.
exactly.
That's my best.
Yeah, let's not go down the road of the preacher's son. Or preachers, for that matter.
There's
That's
so
a
many
whole
jokes
new
about that.
discussion for me there. But it is the case, then, I mean, as a business owner myself, and as an investigator, I've bumped my head, as you know, with staff, our own staff from time to time, because we haven't updated policies and procedures, and just on a simple thing like vehicles.
Yeah.
Taking the vehicle and using it for your own private use over a weekend when you're not allowed to because you were using it to do an hour's work on Saturday morning, comes back to bite you when it's not in your policy that you're not allowed to, and they say, well, I didn't know. So it happens, but yes, it's...
Well, I mean, I'll give you an example. I just had it now, where one of my clients, one of their managers took their Bentley and crashed it.
Okay, at least I don't drive Bentleys.
Okay, but it happens.
No, it does happen. It does happen.
But you've got to cater for those types.
I mean-
If you've got company vehicles, there's got to be a company vehicle policy.
And
Okay,
that policy
I mean,
must be worded that common sense is taken out of it. And no, literally, and it's when because if you're gonna bring charges against a staff member for something in
Or hold them liable.
they got to know that okay, well that was there, I've signed it, and I've made that mistake. I mean, I'll own it, but yeah, it happens. So going back to the foundations, build your foundations and update them if needs be. It's a pain in the ass, but you got to do it.
Yeah.
Well, that's why growing a business, they call it growing pains.
Growing, yep.
It's not growing joys.
Good
That's
point.
the reality of it. I mean,
So I suppose there's labour pains. Fucking labour is pain.
exactly.
That's the way we can look at it. I think not only has this been very informative, but I think one thing I can take away from this, Daniel, is today's session is there's a lot more one could always talk about on these topics, and you're not going to cover it in an hour and a half podcast. But what I would like to put out there is that advice is free, and if you're looking for a professional, you go out and you get advice, and then you take it from there. And I think what you've done is you've dispersed and shared some hell of a significant advice here today. And as I said, I mean, you talk, when you're ingrained in your day-to-day grind, like we get, and we deal with these things and we deal with them, sometimes we too lose perspective on certain things. Law changes happen. You keep bringing up this point, as a business owner, you've got to be an aficionado in virtually every aspect of that business, and that is true. But I keep going back to the toolbox. Have this toolbox of resources, and it's my thing that I always say, to a client is, you have a black book, just like all good journalists have this black book of contacts. We have a black book of sources, of which you are one, and your staff, many of your staff, in fact, because I obviously deal with them a lot more than necessarily deal with you. And that is how you run effectively as best you can the sort of areas of your business that you're not the professional in. And when you're stuck in the hustle and the grind on a day-to-day basis, and you feel like your head is going to explode and you don't have an answer for each thing, it makes a hell of a difference in your life, health-wise, mentally, when you can just say, here's my black book. Who do I speak to about this? And I think today, more than most so far, in terms of what it is Boardroom Soldiers is trying to communicate, is having soldiers on your team. You've indicated, or you've certainly brought the point across as to why we need your line of work.
Well, I'll give you another analogy. I love analogies. Okay? It's like insurance. You crash your car with insurance, you're going to cry a little bit. Okay? It's a little bit of excess to pay. You crash your car without insurance,
You're going to cry a lot.
you're going to cry a lot.
Yeah. So
And it's really the same. I mean, who drives their car without insurance?
every person that
Now,
crashes
the
into
same-
one of my cars. Every
Exactly.
single person that crashes into one of my
Oh,
cars
is this a sore subject?
has no insurance.
You triggered him now.
Well, no. I'll tell you. And no, but hey, to be honest, the last 4 accidents that have been involved with our vehicles, no insurance.
Yeah.
But anyway, that is a fight. We'll have an insurance person on
I
this
feel
show.
an insurance person coming onto the show
Yeah,
now.
but with you, I'm bringing you back. I'm bringing you back for this, and you're going to have it out with him. But no, as I said, I'm a big believer in the black book of sources and having established network of whether it's friends or whether it's allies. It doesn't matter. You've got to have people on your side.
Specialists.
And I think, specialists. Yeah. And I think my view is Invictus is exactly that. And I work and have worked for years now with your staff, who I've always found professional, always.
Thanks.
And
Appreciate it.
they come in, and whether they've dealt with disciplinaries, etc., in my business, or whether they've dealt with disciplinaries on behalf of our clients. And we push. I mean, here's Pierre. I like to tell clients, please do not do this on your own. If you're going down this road, get an independent specialist. And I'm never going to deviate from that. I've seen the importance of it. I've seen how that turns a case in your favor or against your favor, is not having someone with knowledge.
And versus doing it without.
Yeah, exactly. That's what, as that. And trying to wing it on their own.
Yeah, it's always a
using
fuck up.
The young 25-year-old lady from HR now trying to deal with this matter. So I think you've hopefully you've re-strengthened my view on the importance of it, and I think a lot of people who listen to this will now understand. Having said that, though, how do people contact Invictus going forward? You're on social media, for example.
We're on social media.
Where do they follow you?
We're on every social media out there.
As Invictus?
So, Invictus Group.
Invictus Group.
Yeah. So
Okay.
the website is www.invictusgroup.co.za.
Okay.
Okay. And the same applies to Facebook, LinkedIn, Twitter, you name it.
So
The articles are released every week. There's a mailing list that you can subscribe to. You can go to the website. All the articles are posted there as well. And, it's posted there for free. Okay, we're not looking to make, we're not selling paper. Okay, the information that's out there is obviously to benefit employers
100%.
and employees at the same time. It's not just about the employers.
no, that's a good
Fair
point.
procedure protects everybody.
Yeah.
That's a good point.
Okay, I mean, if an employee is not going to get disciplined for following the right procedure either.
No.
It's as simple as
make
that.
a valid point there.
Yeah,
I think.
and I think this is where people get it a lot wrong, is that, an employee that hasn't done anything wrong is not being disciplined. Okay, there is still the master-servant relationship, as the Roman law dictated it how many years ago. That still applies here. both parties have to, exchange their services for cash or money, whatever the case may be, and it still applies.
You mentioned to me just before the show started that you've had an uptake in business in the nightclub industry of late, or the club.
Not just the nightclub industry, but also in business in general. Okay. So we can actually see quite a big
you've seen
growth
of
new money coming into new businesses. So, on a ground level, you can normally see what the economy is like. You can be told by every economist that the economy is terrible and this, etc. But when you're seeing the growth on ground level where people are opening businesses, and I mean, especially in something that is considered a luxury, like the nightclub life and restaurants, etc., still seen as a luxury. Okay, the money is still there. People are still spending. It's still there.
Question for you. Sex worker. Gets paid as a shit pump. Can the client dismiss and get their money back?
They're normally employed as independent contractors, so you're not going to do a poor work performance there, are you?
Just thought maybe there's a line of work for you guys there.
Well, maybe if they're employed by one of the strip clubs and, their strip tease is not up to standard, then maybe you want to do a poor work
for a shit show. Do I get my money back? Daniel, before closing, I just want to again thank you from my side. Our relationship has been going a good few years now, and I know it will continue.
Absolutely, 100%.
We just, from our side, brought a little box there for you as a guest on our
that's nice.
Boardroom Soldiers. You can go ahead and open it.
Great. Let me just open it at the camera.
I know you don't drink, but you are sort of profound to Prime and Biltong, so there's some more Prime for you.
Big shout out to Prime, by the way. if you feel like sponsoring someone,
yeah, good point. Put it out there.
Yeah.
But thank you very much.
Thanks so much. I appreciate it.
Side? If you want to reach us on our socials, Boardroom Soldiers, and our website www.investigators.co.za, or you can obviously contact us on 011 824 0334.
There we go.
And that's it from our side.
All right. Well, as I said to the two of you, thanks. It's always like having a chat. It's Friday afternoon. We've got Springbok Rugby tomorrow, and let's get home safe. And thank you.
Thank you, Daniel.
It's been a pleasure.
Awesome. Thank you.
Another production from Solid Gold Podcasts.